How you doing, guy?
Pretty good, how are you?
Good thing. How's the test, all right?
Yeah, there was one question that I didn't fully understand. Well, there were two, but luckily I had a chance to do the 10.
Which one's bothered you? What's the subject, general subject matter?
I think it asked for 3 items and 3 sub-items. That
Entities, corporations, limited partnerships, stuff like that.
Okay.
That's what you're talking about?
Yeah,
Okay.
that was the answer, okay. And
Good.
the other one was, I think, where I think partners wanted to come together, but they want a whole title.
Partition. How does a court partition a property?
Yes,
Yeah, okay.
yes,
We talked about it. I understand you can't remember all this crud, but yeah.
yeah.
Yeah, there are 3 ways to partition property.
Yes.
Parties, you can physically split the property into 2 pieces,
Okay,
into 2 parts,
okay.
or the court can order the property sold and you split the proceeds, split the money. Or thirdly, one party can buy out the other.
Okay.
Those are the 3 ways. Hopefully you got close. I hope so. That's what I was after anyway with that. The 3 ways are, court, 2 people own this piece of property. Court can split it in half and say, you take this side, I'll take that side. Or the court can say, sell the whole thing and split the money. Or this guy can decide to buy out that guy
Yes,
and own the whole thing,
yes. I looked at it from this perspective of like joint tenants and tenants in entirety. And
Oh, okay. Well, they might be owners that way. Brian, come to me for 2 seconds. Or would you note this in? No, would you have seen it?
Yeah, and discuss the part about Xing one of them off.
Exactly. Your paper looks real good, but you gotta pick one. You gotta pick it, not me.
Oh, God.
No, you
All
pick
right.
it.
Let's
Yeah,
see.
no, it's not fair to everybody else if I take your best 10. You gotta
Right,
decide
right,
which
right.
one to kill.
Okay.
So, take your time, sit down, take it for a minute, decide which one you wanna cross out.
Big thumb for a girl. Oh, you're back?
No, I gotta cross one out, because remember we talked about.
Oh,
it.
you did.
Pretty gung ho answering all 11. And being the first guy finished too.
Oh, yeah, you
But now it's gonna be tough to like figure out which one to cross out.
Right.
I'm saying.
I had trouble figuring out which one.
I just went with the last one. I was like, I'm just not gonna answer the last one.
Last time we did that, somebody said, no, me pick it.
Yeah.
What if you think
There was
you
2
can
that I
answer that
kinda
one?
knew, so I just didn't know which one I knew less of.
That's what it's all about, yeah, no, to me, it's easy to have one really bad subject.
The weak is one.
What if your week is actually strong?
You want more time to think about it?
Yeah.
Do it after class?
Nah.
Okay.
That's why I just took that. I was like,
Perfect.
yeah.
Oh, damn, that was your best answer.
Every time. Yeah,
Can we change the ones we crossed out?
right. I'm reviewing.
Okay, guys, chapter 15, deeds. Deeds are the most important thing we record. And again, we'll do recording, but trying to tie this all together. We record deeds, and we're going to look at some recorded deeds at the end of class. Remember that, without question, preparation of a deed is the practice of law. So we're not trying to teach you how to prepare deeds. I urge you to have a lawyer prepare a deed, because otherwise it, and for those of you who missed the last class, unauthorized practice of law is a felony. You can always prepare your own deed for your own piece of property, but preparing a deed for somebody else is a different matter. That's practice of law. Remember also, we talked about one of our goals is to teach you to learn to speak the language, and that's why we're going to go through all these elements of a deed and what these terms that relate to deeds mean, so you can communicate with lawyers and title companies. And but the idea is not to try to teach you how to prepare deeds. That's my point. Okay. There's a very basic concept with deeds that probably runs contrary to what you're used to if you haven't dealt with deeds before. My point being, you're probably used to transferring car titles, where you sign a certificate of title and you hand it to a guy, your buyer. They send it in and the state sends them a new one. That ain't how it works. That's not how deeds work. You get a deed from your seller and it gets recorded. And once it's recorded, it's there forever. What recording really means is it gets microfilmed and they hand you your deed back. And that's nice. You got your deed and you prove you own it. But the guy who sold it to you, he still got his deed. He could prove he owns it too. Except you got a better deed because you got one from him. But the concept to be, if you go back and look at the chain of title to a lot that's been platted for 50 years, you may find 15 deeds recorded in the public records in order, from A to B and B to C and C to D and E to F and R to T, etc., right on down the line. So the concept being, I just want you to have this general feel for what we're talking about. The title holder of a property signs over a deed to the buyer, and the buyer records it. And then it happens again and again and again. But there's no getting a nice pretty certificate with a seal of the state of Florida sent to you from Tallahassee that says you are the owner. You got a deed from the guy who sold it to you. If he has good title and the deed is done right, you get good title. If he didn't have title, or the deed is done wrong, you got nothing. So we're going to talk about a deed, which is the instrument that transfers title of property. And that's what it is, a written instrument transferring title to real estate. And we're going to talk about types of deeds first. And remember, when we talked about a sales contract, that the type of deed that's going to be used in any transaction gets negotiated and is set forth in the sales contract. The sales contract is going to say, when we get to closing, the seller will transfer the title to the buyer by a deed. A warranty deed, a special warranty deed, a quitclaim deed, a fiduciary deed, the kind of deeds that we're going to talk about. But how you know what kind of deed you're going to use in your transaction, it's what the sales contract said you were going to use, and whether you knew it or not, you negotiated that and agreed upon that when you signed your sales contract, because it's in there somewhere. And it was in the form we went through. And you checked off what kind of deed you were going to use. Okay. The most common type of deed, used most often, used virtually always in residential property, and pretty often in commercial, is called a warranty deed. Now, excuse me, it's also called a general warranty deed. It's called a full warranty deed. The materials talk as if there are two types of warranty deeds, and that's not really correct. And we're going to discuss the differences in just a minute, but I want you to think of them differently than the materials tell you. The materials tell you there's a warranty deed, and that there are two types, that there's a general warranty deed and a special warranty deed. And I respectfully suggest to you that there are two animals here we're talking about, a warranty deed, and we'll talk about in a little while, a special warranty deed. Now, when people say a warranty deed, they mean a full warranty deed, a general warranty deed, a warranty deed. Okay, there are two parties. There's a grantor, and that's normally your seller. That's the person who's transferring the title away. And there's a grantee. That's usually your buyer. It's always the person who's getting title. What I'm getting at is there may not be a sale. You know, in a normal sale, grantor is your seller, grantee is your buyer. But there are times that you do deeds that there's no sale involved. So grantor is the one transferring the title away. Grantee is the one receiving the title. All right. A warranty deed is a deed where the seller guarantees to the buyer, let's revise that, the grantor guarantees to the grantee that the title is good and that it's free of any liens or claims or encumbrances. Meaning, free of any mechanics liens, free of any judgment liens, free of tax liens. Okay. The materials tell you, and you don't need to know this, let me tell you now, don't try to memorize this, that there are 5 covenants in a warranty deed. We're going to talk about in general what a seller is guaranteeing when we say he's guaranteeing good title. But you don't need to know this covenant of season and covenant of this and that, covenant of that. Here's what's going on. The grantor is guaranteeing that he has the right to sell the property and that he owns the property. He has a right to sell it and that he owns it. And that the title is clear, and there are no encumbrances.
Is this all one covenant, or these are
No,
your?
I'm summarizing all 5 covenants because you're not going to have to learn the names.
He owns it. Please, you start again, please.
Seller says,
Um,
Grantor has right to sell. Grantor owns the property.
seller says he has the right to convey the property, and he owns the property, and there are no liens against the property. And then here's one that is a concept we talked about before, called the covenant of quiet enjoyment. In leasing, we said that the landlord gives a covenant of quiet enjoyment to the lessee. Here, the seller to the buyer tells him he won't be evicted by somebody with superior title. So in that sense, it's similar, that you don't need to know the covenant of quiet enjoyment. But the seller's saying to the buyer, nobody's going to kick you out of this property because you got good title. But here, is what a warranty deed is really doing. It is the seller guaranteeing the buyer that the seller will forever defend the title against anybody who makes a claim. He's warranting the title. He's guaranteeing the title. It's a full warranty. Simply put, and let me summarize this, title is good, and there are no liens or encumbrances, no claims against it, and the seller will guarantee that it's good against anybody. Now that's nice. That means somebody comes in and makes a claim against your property, or claims an encumbrance on your property resulting from the seller or somebody in the past. You get to sue your seller. Well, that's wonderful. But the seller is probably taking your money and he's in Tahiti now. So that really doesn't cut it in terms of feeling good. Hey, he guaranteed the title. Can be a very hollow remedy, but it is what's going on in a warranty deed. Seller is saying, you get to sue me if title's no good, or if there are any encumbrances against the title. Now, that if there are any encumbrances thing, understand, however, that a warranty deed normally says there are no encumbrances against the title except the following. And then it lists. So this is kind of like a warranty with the following exceptions, bless you. And the seller probably says then, if there are any mortgages on there, if the taxes are paid or not paid. In other words, it's a warranty against everything bad about the title, except for the matters that seller says title is subject to. So when we look at some warranty deeds, you're going to see paragraphs where it says, subject to, So the seller says, but I ain't guaranteeing against these things. Okay, that's a warranty deed. Now, Florida, by statute, has a form for a warranty deed. You don't need to know this. Section 68902 says form of warranty deed prescribed, and it says warranty deeds shall be in the following form. But there's a lesson here. The lesson is this. Anytime there's a governmental form for something, use it. Don't decide you're smarter and you know more than the legislators who passed it, because you're protected if you use a government form. And there are government forms everywhere. There's a statute here for a warranty deed that says warranty deeds will be in the following form. Maybe in the following form. If you go to the SunBiz website we've talked about, Secretary of State, you'll find forms there for forming a corporation, for forming a limited partnership, forming an LLC. Use them. Point is, if the government puts out the form, it's been approved by somebody. You can make it longer and add more stuff if you want, but whatever you'll find in a statute or a rule or a regulation is going to be the bare minimum. Make sure you do everything that's there, and more if you want, but never less. So there's a form for a warranty deed, and it's pretty simple, and it closes with the following line that you'll see in every warranty deed, and what tells you it's a warranty deed. Now there are two things that tell you it's a warranty deed. One thing I'm about to tell you, and the other thing is usually up in the upper left-hand corner. It says warranty deed. That's a clue. But it also says at the bottom, after the legal description, and the said party of the first part, that's our grantor, does hereby fully warrant the title to said land. and will defend the same against the lawful claims of all persons whomsoever. That's what I told you last. Will defend the title against anybody who makes a claim, and if somebody makes a claim against the title, the buyer gets to sue his seller if he got a warranty deed. Okay, so we got a statutory form for that. Now, there is another type of deed. Again, the materials called it a different type of warranty deed. I call it a different animal completely. It's called the special warranty deed. And in Florida, you're going to hear this described as a special warranty deed, but the prior one is simply a warranty deed. Special warranty deed, excuse me, the materials talk about it as a limited warranty deed. And here's what's going on. The seller says simply, yeah, I warrant the title, I guarantee the title against anybody claiming by, through, or under me. What that means is, for the period of time I, the seller, have owned the property, I haven't screwed up the title. There are no claims against me, but I'm not guaranteeing you all the way back in history that there are no claims. In that full warranty deed, if you got a deed, a full warranty deed from somebody last month, and a title claim came up today, and that claim was for something that happened in 1953, you got to sue your seller for it. He guaranteed title was good. But in a special warranty deed, under those same facts, you wouldn't get to. Under a special warranty deed, the seller would say to you, for the 5 years I've owned the property, there are no claims against it, created by me or through me. Nobody's got a claim against me. Nobody's got a claim against the title for something I did. That's a special warranty deed. Now, big companies with deep pockets, I keep using the example of General Motors. General Motors would never give you a warranty deed, a full warranty deed, if you bought a piece of property from them. They don't want to guarantee the title of the property all the way back to the treaty with Spain, which is where our titles start here in Florida. But they will guarantee the title for the period of time they've owned it. Because, as we talked about, if the title is bad, the buyer gets to sue the seller. Well, if the seller has a deep pocket, that means something. If the seller is good for a judgment and could be levied upon and be forced to pay a judgment for a bad title, then the warranty means something. So somebody with a deep pocket doesn't want to give a full warranty deed and be guaranteeing the title for the last 200 years. He only wants to guarantee it for the period of time he's on it. That's a special warranty deed. And in the sales contract, it'll say what type of deed you're going to get. And it can be negotiated between the parties, and you do see it. With you submit a contract to a big corporation, you're buying a piece of property from Nova University, I guarantee you they would not give you a warranty deed. They give you a special warranty deed for the period of time they've owned the property. Because they'd be good. They're good for it. Their warranty means something, and therefore they want to protect themselves and limit the warranty to just the period of time they've owned the property, which makes sense. But in your standard residential deal, people don't make that distinction. Pre-printed residential sales contracts say there'll be a warranty deed. You have to cross it out and change it. Commercial contracts have a blank and say what I think you check a box in the one we looked at recently. So, that's the second type of deed, a special warranty deed, and the only difference between these things is how big a period of time the grantor is warranting the title. All right. The next type of deed described in your materials, you are not responsible for forgetting. A bargain and sale deed. I've never seen one. I've never seen one in Florida. We don't use them. We just don't. Don't forget it. So the third type of deed I'd like to get you familiar with is called a quitclaim deed. Half of the laymen think it's quick, Q-U-I-C-K. It's not. It's quit, Q-U-I-T, claim. And what that is no warranties at all. Zip. I'll be glad to give you a quitclaim deed right now to this building. I don't care. It's no good. I didn't own it. I didn't guarantee I owned it either. If I have an interest, it conveys the title. If I don't have an interest, it conveyed my interest, but it basically conveys nothing. So in a quitclaim deed, the seller's not guaranteeing anything and not even saying that he owns it. He's not saying he owns it, he's not saying he has the right to convey it, and he's definitely not guaranteeing the title. He just says, seller, again, I say seller, actually seller's a bad term here, and that's why I wanted to make this distinction. In a sales transaction, a buyer would never agree to take a quitclaim deed from a seller, but you use them to clear up claims to title. 10 old heirs who you needed to get deeds from way back in the old days, who forgot the deed. Husband to wife in a divorce. There's no sale, there's no negotiation of title, there's no reason for the wife to guarantee the title of a husband when she signs it over. Family members, gifts to family members. Mom deeds a property to a daughter, takes back a life estate maybe we talked about. Why would mom want to guarantee the title of the daughter? Why would the daughter expect mom to guarantee it if it's a gift anyway? So there is, it basically, it fully conveys the title, fully conveys whatever title the grantor has, if any. But the grantor ain't saying he got anything, and is not guaranteeing that he has anything. That's a quitclaim deed, sometimes one word, sometimes two. Just depends. That's what they're generally used for. The fourth and final type of deed is a fiduciary deed. We talked about, and I've forgotten exactly where, yeah, under a listing agreement a little bit, I think, on the brokerage chapter. A fiduciary, of course, is somebody who's in a position of trust and owes a special duty to somebody. A trustee, a guardian, a personal representative in an estate, a person serving in a capacity of trust, and in our context, it happens to own a piece of property. When that person sells a piece of property, doesn't want to guarantee the title. If I'm trustee holding title to this property on behalf of you, if under a trust agreement, I'm your trustee and I'm holding title and I'm going to convey the property, I don't want to guarantee the title. I'm going to guarantee one thing only, and this is what the fiduciary guarantees. The fiduciary guarantees that he or she has the right to convey. Now you have to put that into the context of your situation. If it's a guardianship, it means I am properly appointed by the court as a guardian and I have the right to sign this deed. a trust, I am the trustee, the trust gives me the power to sign this deed. An estate, I am the PR, the court has given me the right to sell this property. But that's it. I have the right, under whatever instrument has appointed me to this fiduciary capacity, to sign this deed. But I'm not saying the title's any good. I'm not saying that whoever I'm conveying for, in other words, if I'm a PR, I'm conveying for a dead person. If I'm a trustee, I'm conveying for a beneficiary or a guardian for a ward. But the point is, I'm not saying they have good title, and I'm not saying I have good title. And none of us are going to warrant the title. All I'm telling you is, I have the authority under whatever instrument it is that appointed me to sign this deed. That's a fiduciary deed. So those are our 4 types of deeds in Florida. Warranty deed, special warranty deed, quitclaim deed, and fiduciary deed. Now, every deed has got to contain certain elements to be a good deed, to be a valid deed, to work, to properly transfer the title. If it doesn't meet all these tests, then it's not a valid deed. Title doesn't pass. Okay. First, it's got to have what the law calls words of conveyance. They are things like, I grant, convey, bargain, and sell the property. They usually say that because lawyers do stupid stuff like this. They say one thing 4 different ways. They all mean the same thing. Any one will do, but usually they say them all. Grantor grants, bargains, sells, and conveys to grantee the following described property. Those are words of conveyance. You got to have some. You got to have one of those at least. So you can tell it's a deed and tell it was intending to convey some property. Secondly, you got to have a competent grantor. Now all this means is adult age, not a minor, not incapacitated, meaning insane. Corporations and partnerships have special rules about they have to be in good standing. You know, they have to pay their taxes and annual fees and all that. But there are tests to make sure that whoever the grantor was has to be competent, meaning able to convey. All right, you got to have an identifiable grantee. Who's the buyer? Who's getting title here? Is it real? If it's a person's name, that's pretty easy. Hopefully there's a person by that name. Things like a not identifiable grantee would be if I did a deed to all the members of the congregation of the First Baptist Church. You don't know who that is. And next week is probably different from who it is this week. You would convey to the church, which is a nonprofit corporation. Something that happens often, and you need to be careful of if you're in a situation like this, because we've talked about, and we will talk about it, talk about again. What if you want to form an entity for a bunch of you to take title together to a piece of property? We want to form a corporation to be the grantee in this case, to buy this property. Well, you got to have it formed before it gets property deeded to it. You can't do a deed today to the XYZ Corp and then create and file the XYZ Corp next month with the Secretary of State. The entity has to exist at the time of the deed. Okay. You have to have an adequate legal description. That means basically that you can properly figure out what piece of property you're conveying here. Next week we have a chapter called Legal Descriptions. We're going to talk about what's an adequate legal description. It depends on the nature of the piece of property, what's an adequate description. We talked about street address is not. We've already talked about that, we'll talk about that again. That's not a legal description. And we will, again, we'll have a whole chapter on what it is, but a deed is no good without a good legal description, because you can't tell what's being conveyed. Deed has to be properly executed. That means it's got to be signed right. Now, it gets signed only by the grantor, only by the seller, not by the grantee. In regard to proper execution, in most states, a deed doesn't have to be witnessed, but in Florida it does. That means two witnesses have to sign next to the signature of every grantor saying, I saw him sign it. That's called attestation. Attestation, the witnesses attest to the fact that the seller signed it and I saw him sign it. Florida requires two witnesses. Now, in addition, in some states, and I'll explain to you in Florida, and we're going to go back to that witnessing thing in just a minute, but I want to be sure that we cover this concept. Deeds, part of proper execution is the question of whether or not a deed has to be notarized. Interestingly, in Florida, now some states require a deed to be notarized. Some states require witnesses and no notary. Some require a notary and no witnesses. Some require neither one. Here's the deal in Florida. You're going to have a deed notarized in Florida because it can't be recorded unless it's notarized. So this is splitting hairs. A deed in Florida is valid without a notary, but you don't want one without a notary. Because in order to be recorded, it must be notarized. Still works, here's what this means. As between the seller and the buyer, it's valid, it works without a notary, but it can't be recorded. Now I want to go back for a minute and discuss at some length this concept we talked about it having to be witnessed. I want to talk about the Florida statute of frauds. And we've talked about this a little bit before, and we're going to talk about it at length now. Florida has a statute. Every state has a statute, but they're different in every state, called the statute of frauds. We talked about it in conjunction with leases. We said that it required all leases in excess of a year to be in writing. Florida has a statute of frauds, and it says any interest in land for a term of more than 1 year shall be by an instrument in writing, signed in the presence of two subscribing witnesses by the party doing the transfer. It says, or his lawfully authorized agent. We're going to talk about that in a minute. But the point is, Florida statute of frauds says that any deed and any lease for more than 1 year must be in writing and must have two witnesses. And that's the statute of frauds in Florida. Believe it or not, Florida adopted this in 1828. Hell, it didn't become a state until 1845. But as a territory, it passed the statute of frauds, which started in England, and the different territories all adopted them. But that's Florida's. Florida's is, remember we talked about this came about to prevent fraud so that there would be some written record of conveyances, and the basic statute of frauds in most cases is, most states is saying, what has to be in writing. Florida and its adds with 2 witnesses. Okay, now, so it has to be properly executed by the grantor with 2 witnesses, and you're going to want it to be acknowledged, that's notarized, that word is called acknowledgement, in order to be recorded. There is one exception to the rule of the grantor having to sign it, and that is a power of attorney. And I want to talk about a power of attorney, what it is and what it does. We've talked about it a little bit previously. And I want to make sure you understand that having a deed executed pursuant to a power of attorney is not a good idea, and we'll talk about why. But it gets done anyway. A power of attorney is very much like a listing agreement that we talked about in the chapter on brokers to this extent. It has a principal and it has an agent. In our context, the principal is the person who owns the piece of property. And in the power of attorney, that principal appoints an agent to do something for him. That agent is called an attorney in fact. And that's why it's called a power of attorney. It's given to an attorney in fact. Now that has nothing to do with an attorney at law whatsoever. The name of the document is power of attorney, a principal authorizing an agent to do an act. And when we talk about it in this real estate context, and it's a written instrument, of course, when we talk about it in this context, it's going to be the owner of a piece of property appointing somebody, an agent, an attorney in fact, to sign documents on that owner's behalf. Now, there are 2 very scary things about a power of attorney. Number 1 is it can be revoked by the person who gave it at any time merely by saying so. You don't have to go get the power of attorney document back from whoever you gave it to. You just declare, I revoke. It's over. The agent from that moment forward has no further power. And it is instantly revoked upon the death of the principal. The moment the landowner who gave the power of attorney dies, the power of attorney is revoked automatically by operation of law. So, you're sitting in a closing, and you're going to buy a piece of property from somebody, and they say, well, he can't come, but I got his power of attorney. Well, you better hope he's still alive, because if he died a half hour ago, got run over by a car, you don't know it, that power of attorney is void. Period. No good. Or, if wherever he was, he decided, I don't trust that guy anymore, I revoke. That's it. He doesn't have to give it to you, or give it to the title company. If you revoked it, it's revoked. So you really, it's hard to get excited about letting someone else, about accepting someone else's signature by virtue of a power of attorney. Banks won't accept them at all for executing mortgages. You go borrow money from a bank, they will not let the borrower sign their documents under a power of attorney, period. Because he might have died a few months ago. The documents are totally void. So they say, fine, well, we'll have the closing next week when he comes back. Likewise, you delay closings until people can get there or until they sign the documents wherever they are. You know, you got somebody who's stuck in Ohio and can't come to a closing, fine. You email him the document, let him print it, sign it, get it witnessed and notarized up there. FedEx is back here tomorrow. But you get the right person to sign it. You don't let somebody show up with a power of attorney and say, I'm signing on his behalf, because he may be dead. Then you can get him on the phone and see if he's still alive. That's nice, but you know, you still might have revoked it. They just are a bad idea. Now, having said that, I want to tell you a question that I asked on last year's exam. I said, you're dealing with a piece of property that's owned by Joe Blow, and we're going to talk about estates in a few minutes, but you find out Joe Blow's dead. And Joe Blow Jr. says, I'll sign for him, don't worry, I'd be glad to sign. And you know he's dead. So I said, so what kind of document would you want to show that Joe Blow had the authority, Joe Blow Jr. had the authority to sign these documents on behalf of his dad? And half of the class said, power of attorney. And I thought, Jesus, I must not have said that 10 times. I needed to say it 15 times. Death revokes a power of attorney. Period. Don't let anybody say, oh yeah, he's dead, but I got his power of attorney. It's no good. And that's why you don't want to use them. But they're going to get offered to you in all kinds of cases. Sometimes it's all you're ever going to get. So you take what you can get, but you've got to know going into it that this may be a problem.
So what did you need? Just the,
I'm sorry?
what did you need?
Well, one that's a case of an estate, which we're going to talk about in another chapter. When somebody dies, the person that gets appointed to handle the affairs of the estate is called the personal representative. And the court appoints the personal representative. And then it's the personal representative who signs for the estate. But we have another chapter on that. My point is that the power of attorney is gone the minute somebody's dead. If you know they're dead and somebody whips out their power of attorney,
But if there's a will, you're still conveying on the will, right?
a will appoint a personal representative, but that doesn't mean anything either. Until the court, no, that's a start. Until the court appoints the person as personal representative. When a person says in their will, I hereby appoint my son as personal representative, well, that's nice. But you don't get to appoint your personal representative. The judge does. So you file a probate, and you file a petition with the judge, and you say, Your Honor, Dad died, here's Dad's will, he wanted me to be PR, will you make me PR? And then the judge, about 6 weeks later, signs an order called Letters of Administration that says, I, the judge, appoint Junior as personal representative of Dad's estate.
So
And that document is what gives you the authority to speak for a dead person. The letters of administration, not even the will. The will is helpful to the judge of who we're going to appoint, but he's still not the personal representative until the judge says so. Okay, but that's another chapter, and that's coming. The lesson here is forget a power of attorney when they're dead. So, okay. Talk about for 1 second, just because I skipped it, we talked about how documents have to be signed. Special rules for a corporation. We have a statute in Florida. I think I talked about this once before in some context, but I can't remember which. President? Yeah, we talked about who signs when we talked about it in our chart. Who signs? President, any vice president, or the CEO. Because we're talking about who has to sign a deed. The deed is signed by the owner, but if it's a corporation, it's signed by one of those parties. Okay, now, part of that was the elements of the deed. That's where we were. What do you have to have in order to be a valid deed? And the last one has to be properly executed, as we just talked about. But the last one is, it's got to be delivered. What that means is, the deed, let's say a seller signs a deed for a closing next week. It doesn't transfer the title the instant the deed is signed. The seller has to deliver the deed to the buyer, and the seller doesn't deliver the deed to the buyer until he gets the money. So people do sign documents in advance of closing, and they give them to their lawyer to take to the closing. But until the lawyer delivers them, hands them to the buyer or the buyer's title company or the buyer's lawyer to record them, only then do they become valid. What happens a lot is old folks will sign a deed to their property to one of their kids, and they'll put it in a drawer. And it gets found after they died, 20 years later. 20 years after they signed it, maybe a few months after they died. The question is it valid? No, it's not valid. It was never delivered. Wasn't delivered during the lifetime of the grantor, by the grantor, to whoever he intended to convey it to. And he needed a will. Of course, the sad thing is, but he doesn't put it in his will because he thinks he's got a deed in the drawer. You know, but the point is, it has to be delivered during the lifetime of the grantor to the grantee, or to the grantee's agent, or the point is, needs to release the deed with the intention that it become effective. Okay. I want to talk about one more concept of deeds that we've touched on a little bit, and then we're going to go look at some deeds and see what these things are all about. And it's the concept of deed restrictions. In a deed, you can put restrictions regarding the property. Usually, it's regarding the use of the property. And you can put it right in a deed. Something as simple as, this property may never be used as a bunkhouse. Okay, fine, it can't be. Now, we talked about this early on. I gave you that example of Birch State Park, transferring the title of Birch State Park so long as it remains in its natural state. We talked about that in some of these deeds, in some forms of deeds, if a condition or a restriction is violated, title can be forfeited and can go back to whoever gave it. Or maybe it gives the person who imposed the restriction the right to bring a lawsuit to compel compliance. But the point is that a grantor may, in a deed, restrict the use of property. This is basically private zoning. This is a, we have zoning laws to determine what can you use a piece of property for, but we also have parties can restrict what you can use a piece of property for. And you kind of think sometimes, well, where or why? Well, maybe it's next door. Maybe I own this piece of property and I want to convey this part here. And I want to provide, I don't want you to build a house any bigger than 2,000 square feet because I don't want to look at it. I don't want you to build it any closer than 20 feet from my sideline. In other words, it might be adjoining property. You might have very valid reasons for caring what it's used for. I don't want to look at it. I don't want to deal with it. I don't want to smell it or hear it. But it can go a lot further than that. A developer can own an entire piece of property and break it up into a bunch of lots and then put all kinds of restrictions on it. No filling stations, no orange houses, no yard blowers, restrictions. You can put all these things in restrictions so that if a developer developed a parcel into a bunch of individual lots, in each deed, he can put provisions in there restricting the use of the property. And he might put that same restriction in everybody's deed. No yard blowers in everybody's deed. No pink houses. no factories, even forgetting zoning, assuming there weren't any zoning at all. This is private land use control. And you can put those provisions in a deed. And they're enforceable. And those are called deed restrictions. Now the materials go on and want to talk at length and differentiate between covenants and conditions and affirmative covenants and restrictive covenants. People don't use those terms. They are restrictions. Whether they restrict the use, which are you may not, but they can also be affirmative. If you take, it may say, if you accept the deed, you must put a hedge in front of your piece, in front of your house. Not just prohibitive, but affirmative.